from the Unreasonable Doubt Studios, in association with Feitner Productions, this is Laying Down the Law with your host, Billy DeClercq, and co-hosts, Kristen Drenning and Curtis Rutherford. Featuring a jury of genius jokesmiths and paneled with the help of Publishers Clearinghouse, auditors from the firm of DCH Lottery Management, and selected by random draw from a hermetically sealed mayonnaise jar every Tuesday and Thursday at never. Only a madman would bring these people together to construct an entire virtual world of law and order, simply to tear it asunder with ruckus laughter. That madman is attorney Billy DeClercq. The result is a podcast blasted to the farthest reaches of the interwebs. That podcast is this one, and it starts right now.
Welcome to Laying Down the Law, a comedy podcast hosted by me, a lawyer, and potentially a comedian, Billy DeClercq.
And I'm co-host Kristen Drenning, also an actual lawyer, a storyteller, improviser, and general gal about town in Austin, Texas.
And I'm co-host Curtis Rutherford, the co-host of this podcast and the creator of Improv Beat by Beat, the audio interview textbook of improv comedy, and also the non-legal, non-improv book, laser focused on SAT math. And I am not a lawyer, so do not come to me with your legal needs.
Actually, don't come to any of us for legal needs. Nothing that we say today constitutes legal advice, may not be relied upon for any purpose. And should you be injured as a result of following any of the advice on this podcast, you may not sue us. We'll sue you. Well, I'm glad to have my co-host today. We're changing the format a little bit, so we don't have any guests, but we're going to be trying some new stuff. But first, let's take a break to thank and acknowledge our supporters. Thank you to our supporters. And without any further ado, let's get into it. The case of the week is United States versus Hatahley. This is a 1958 case out of the 10th Circuit. It's a federal court case. And for those of you who didn't take federal civil procedure, which I'm assuming is many listeners, the 10th Circuit is a federal appellate court that covers Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming. And this case occurred in Utah. The background of the case involves conflicts between farmers and the Navajo Indians in Utah. The plaintiffs in the case are 8 families of Navajo Indians who lived for generations on open range land that was, quote unquote, owned by the United States. And their livestock grazed on public lands along with livestock owned by whites who held grazing permits. The United States and the white cattle ranchers considered the Indians, and side note, in federal jurisdiction, Indians is the legally accurate term, even though it's outdated and some people would consider offensive, but that's the term that's used in sort of in the law. So Indians is a legal term of art. I'm referring to the native people of this great land of ours. The United States sued to eject them from the public lands. While those lawsuits were still going on, the government rounded up all of the Navajos' horses and burros and sold them to a glue factory.
Ugh. It's terrible.
Law and comedy podcast, folks. Federal law required that the so-called trespassers had to be given notice and an opportunity to remove their animals before there was such a roundup, but no notice was given. So the Supreme Court of the United States held that that was a trespass applying Utah law, and we don't even need to get into the Erie doctrine when you apply state versus federal law. Because the United States violated the law, the Navajo families were permitted to file a lawsuit against the United States under a statute called the Federal Tort Claims Act. That's a lot to digest. The Federal Tort Claims Act is a federal law which waives sovereign immunity. Sovereign immunity means you can't sue the government. The government's immune from lawsuits. Sovereign immunity can be waived in certain situations. And so there's this law that was passed that says you can file a lawsuit against the government in this scenario. So that's how we get here. Now, this is from my Remedies textbook. Remedies is often taught as a third-year class. I took it in the third year. It's one of my favorite classes. So remedies are the reason people go to court in the first place, is how are you going to fix it? I often tell people that the law isn't really good at fixing real world problems. It's good at moving money from one place to another. And usually that's how we solve most problems. That's the remedy is we're going to take money from one party and we're going to give it to the other. Some things can't be remedied that way. And so the whole course in remedies is what are the different ways that you can try to make people whole? The idea being of a lawsuit is that you're going to put the plaintiff, if the plaintiff wins, in the same position that they would have been in if they hadn't been harmed. That's the basic rule of tort remedies, is the status quo ante, that you put the person back the way they would have been before you rear-ended their car or hit them with a mallet or, caught their finger in a meat grinder or whatever else nasty thing happens. Try to replace, what's the value of their bodily injuries? What's the value of getting hit by a mallet? What's the cost of a finger lost in a meat grinder? And those things are very inexact. That's the context that we find ourselves in here. The issue in this case then was the damages to the Navajo families based upon the loss of their horses and burros. So we are at this phase in the case, basically presuming the government's liable. They're going to have to pay something. And the question is, how much? The basic rule of damages in this case, and it's a tort case. Tort is an involuntary relationship, not like a contract relationship. Typically an accident or an injury or some kind of a wrong, not the delicious dessert. For those of you who have been listening for a while, you'll know that, or if you went to law school, you know that. But what measure would be required to put the Navajo families in the position that they would have been in if their animals hadn't been wrongfully taken and sold to a glue factory? Sorry.
On the behalf of every young girl on the planet, I'd say that's impossible to do, right? Those poor ponies.
Because nothing's funny about selling animals for glue. We're going to take a break. And when we come back, we're going to do Comedy Court, a new feature on this podcast. And we're back. Welcome to Comedy Court, Judge Billy presiding. Today we have the case of the United States versus Hatahley. Arguing on behalf of the Hatahleys, we have attorney Kristen Drenning, and arguing on behalf of the United States of America, we have non-attorney Curtis Rutherford. The question presented to the court today is, what is the value of the burros and ponies that were sold for glue by the bad United States, and how much is the United States going to have to pay the Hatahleys and others based upon their tortious behavior?
Can I object to the judge saying bad United States? Is that allowed?
You absolutely may object. Your objection is noted and overruled. But the United States is terrible, and what they did is despicable. Just letting you know, that's my point of view. That's got nothing to do with the case. I'm not biased at all, but it's absolutely disgusting what the United States has done in this case. But by all means, you're going to get a fair hearing today. So don't worry about it, United States, big bad government, you. Oppressing
I'd just like to
people.
emphasize on the record how disgusting and bad this behavior was, because it was shocking to the nth degree and devastating.
And as a fictional representative of the United States, I would also like to say, yes, it was absolutely terrible and awful, but I think that doesn't affect the damages, but we'll get to that.
Absolutely. Well, plaintiff, as the prevailing party here entitled to damages, the court will hear argument based upon what the measure of damages should be for these some 350 horses and burros that were wrongfully destroyed by the United States.
So I think the most important thing that we note is that this is not just an everyday person who's lost their pony. And I'd say everybody loves a pony if they have one, but especially to this Navajo tribe, they were a part of the family. They were, intrinsic to their everyday life. They were more important to them than I think historically you could point to any other culture. Really, these were about as intrinsic as they could get to everything. So they were just completely devastated by this loss. These are really great, well-trained horses that helped them, facilitated all of their lifestyle. And then they just get, in one fell swoop, turned into glue. Can you imagine the amount of pain that would cause? It's impossible to imagine. And also, those horses are pretty much irreplaceable.
So can you fix a dollar amount
I mean, I think that's the real trouble is like you have to look at like how would their entire lives go now that they are like they have no access to these horses that they relied upon for all of their commercial activities. I mean, and their livelihood in general. It's almost impossible. You can't just say like, oh, you can replace them because these horses are irreplaceable. And also, every day that they're not there, it's going to be felt acutely, and it's going to be felt in the economic sense that they're not going to be making the money they would have been able to support themselves. So, I guess it would be just sort of how much were they used to their lifestyle before this horrible like deprivation occurred, and then also some amount of pain and suffering.
Pain and suffering and the loss of the horses. So, counsel, I'm in no way biased towards the plaintiff, but I'm entirely inclined to award you pretty much whatever you ask for. So based upon that compelling argument, what would you like to ask for as damages in this case?
Well, again, these horses are irreplaceable. It's impossible to fix a value for them. But I would say at least, I don't know. This is a tough one. I think maybe $5,000 per plaintiff for pain and suffering, and then $350 or so per horse, something along those lines.
And that's your final request.
Subject to review.
Well, I'll hear the United States argument, but I'll just tip my hand. I would have given up to $1 million per horse had you asked, but you asked for $350. I was so persuaded and compelled by the force of your argument that I have no choice but to award you whatever you asked for. But, congratulations on asking for so paltry of an amount when I was willing to award much more. United States, represented by Mr. Rutherford, please proceed.
Irreplaceable? Irreplaceable is what we have been told over and again about these horses. But here's the thing. I've gone through goldfish after goldfish after goldfish. My children think they've had one goldfish for 27 years. I have a 27-year-old, very dumb child. But as far as he's concerned, he's had one goldfish over and over and over again, and I can easily replace it. Now I know what you're saying. A horse is better than a goldfish. Of course it is. But still, if you put a horse in front of me, closed my eyes, switched it with the different, identically colored and sized horse, I would go, well, that's the same horse. I can't tell the difference between horses after a certain amount. Now, maybe it's because it's a pet. Sure, maybe you get to know it more. So we can then talk about the use of it, right? Because obviously this is used. Now, it being, I believe, 1952-ish, my calendar broke, but let's say it's around 1950, or is it 1957? Whatever,
somewhere in that range, in the 50s.
Somewhere in that range.
We're
Again,
in
my calendar in the 50s.
58.
I only have a decade calendar, which only tells me the current decade and no more information. It was cheap. I bought one. It has 8 pages, and hopefully it'll last me my lifetime. But we can easily replace horses also in terms of use. In fact, there is an invention which can replace not merely one horse, not merely 10 horses, but has up to, I'm going to say, 500 power of horses contained within it.
Objection. This is all predicated on the idea that the Navajo were traveling roads and therefore could use cars, which I think is counterfactual in the
Counsel, we'll instruct you to hold your argument. I'll reserve some time for rebuttal.
Sorry.
That's fine. We'll reserve some time for rebuttal, and we'll let Mr. Rutherford finish his argument, and then we'll proceed from there.
Now, of course, you're right. They're not merely traveling on roads. However, we also have to take into account the fact that any other replacement wouldn't require the same time and cost that a horse would. A horse, you're constantly pouring oats into it. You're brushing it over and over again. This is lost time, lost money. So I hold that we actually have helped the Hatahleys by removing a cost sink from them. And as such, I'm going to say they should be awarded, let's say, negative $500 each. They should be paying us approximately $500. We also shipped them to the glue factory for free. That was a free shipment. So I, as the government, again, or representing the government, which, although in many ways terrible, and in pretty much every sense in this way, we can all agree, wrong and terrible, I'm going to say silver lining.
I appreciate the force of your argument, and I'll say I think there's a word chutzpah I think of plaintiff, since you got to go first, and since I clearly favor you in every way because what was done was terribly, terribly wrong, I'm going to give you a chance for rebuttal.
I mean, I think it's very clear that this is a very glib attempt to somehow diminish the importance of these actual individual horses to these poor affected plaintiffs. I mean, come on, they raised these horses from infancy. They fed them oats. They brushed them. That amount of care is it's because they loved and cherished them. Also, they were training them during this time. You can't just swap out horses and expect that every horse is going to know, for example, how to walk along a very narrow trail, which I'm sure is certainly a part of what their duties were. But more importantly, I don't think the government has any right to tell us that we have to be more efficient in our choices of animals that we care for or livestock that we raise, right? If we choose to have an inefficient quote unquote animal that's not a car, that's our choice. The government doesn't get to turn our animals into glue and then give us a car. That's not equal compensation at all.
Counsel, after hearing both sides and being completely fair-minded and in no way biased whatsoever for either side, I'm going to just comment that I think that what the United States did here is horrible, monstrous, atrocious, cruel, cold-blooded depredation, and done with no sense of decency.
Yeah.
As such, I'm going to award $350 million to the Navajos in compensatory damages and $350 million in punitive damages.
Oh, yeah.
I'm sure the United States can just borrow money and pay that off, so we'll be fine here. Case concluded. First of all, what do we think of my judging before we move on?
Excellent.
Yeah.
Very fair.
Terrible. I think you should be removed from the bench.
Perfect. Well, in this case, the district court, that's the trial court in the federal judicial system, the district court awarded each plaintiff $3,500 for pain and suffering. So the judgment against the United States in the actual case was $186,017.50. The value for each horse and burro was $395, and each plaintiff received $3,500 for pain and suffering. In addition, the district court gave damages for 1/2 the value of the diminution of the herds of sheep, goats, and cattle between the dates the horses and burros were taken in 1952 and the date of the last hearing in 1957. So in essence, what the district court said is that because the plaintiffs didn't have use of the horses and burros, they weren't able to maintain their flocks. And so it diminished the value. And the court said that 1/2 of that diminution of value was awarded to the plaintiffs. So pretty one-sided in favor of the plaintiff. The Court of Appeal starts by saying that the fundamental job here is to put the plaintiff in the position that they would have been if they'd not been injured. And so what they should have been awarded was the market value or the replacement cost of the horses and burros at the time they were taken, plus the use value of the animals that they would have had during the time they could have reasonably replaced the animals. The 10th Circuit, and continuing to hose the tribes, said that the plaintiffs failed to show the replacement cost of the animals, but basically said they couldn't be replaced because they had particular nature and training. However, there was some testimony that a horse could be traded, and they came up with an estimated value of $395 per head, but there was no consideration given to what the replacement cost is. The district court didn't consider the availability of other horses and burros that were in the local area and what the value. And the 10th Circuit said that that was a mistake. What they should have done, according to the 10th Circuit, is the trial court should have considered what it would have cost to get new horses and burros with similar training. And they should consider all the different elements that go together to make up like value. So basically rejected the idea that these animals were special or had some particular value that was above and beyond what it was to replace them. The loss of use, essentially, the Court of Appeal completely rejected the argument there and said basically that there was no connection between the loss of use of the animals and the diminution of value of the herd. That had they just gotten new animals, they could have maintained the herd and they could have shown loss of profits. And so they completely threw out how the court arrived at the loss of use determination.
It's interesting that all of these are, we think that they speculated too much, so we're going to speculate our other speculate. We
Right.
think they speculated these were irreplaceable. I'm going to speculate that they were replaceable. We're throwing it out, right?
Mhm.
It's like, 50% seems arbitrary, so we're going to give 0%.
Yeah.
Another arbitrary number we've chosen.
Right. Well, and there's a procedural aspect. So what happens when you have an appeal, something like this, where there's been fact finding at the trial court level, the Court of Appeal basically says that was bad fact finding. Go back and do more fact finding with this guidance. And so at the end of the opinion, they're reversing, and then what's called reversing is you overturn what it was before, obviously, and then it's followed by a procedure called remand. And remand is when the appellate court says to the trial court, go back and do your job again, but do it this way, the way we're telling you to do it. So we're correcting your errors of the law. We're not going to find the facts. We're not going to take evidence. There isn't evidence here for us to reach a new opinion. So you have to go back and use these rules, which we're telling you, these are the rules, and go back and do it again.
So there's the possibility then during remand that if they find out, a similarly priced horse is actually $10,000, then it could have been way more. It's just,
right.
They just have to find it under these new rules that
right. Bring new evidence of, using these rules for the evidence. Yeah.
I find it very telling, though, that in this case, they remanded and instructed the judge of the lower court to recuse himself. They were just like, nope, you have no more say in this, I guess.
Yeah. I was going to,
yeah,
we're going to, that's a policy point at the end is the recusal point. In a case about remedies, kicking off the trial judge. But yeah, the Court of Appeal said that the loss of use value was arbitrary, pure speculation, and purely erroneous because they didn't take into consideration what was done with the herds, how they were sold, what the value was at time point A versus time point B. There was just no evidence of that. So the evidence by the plaintiffs said that losing their animals made it difficult for them to obtain and transport water, wood, food, and game. They were less able to travel for medical care and to tribal council meetings and ceremonies, and they weren't able to grow crops and gardens as extensively as before. The court says these were factors on which the damages for loss of use could have been based, but they don't establish what those losses were, a measure of what the position they would have been in versus what their actual position is. So you have to go back and show that. But the Court of Appeal hoses the plaintiffs yet again by saying the time of the loss of use is going to be limited by the amount of time that passed between when they were wrongfully taken from you and the time at which you could have reasonably replaced those animals. So 5 years was way too long. We need to find out you need to have evidence as to how quickly replacements could have been procured and trained if necessary, and enabled you to do all these things that you were going to use the horses and burros for.
That strikes me as really harsh because they were operating on the assumption that they didn't have to replace them because they were pursuing this lawsuit, right? I mean, they might have taken some steps in the interim to do that if they had known that was going to come back to bite them.
Mm-hmm. Yeah, and this brings in the theory of mitigation of damages, just that you're required by law, if you're an injured plaintiff, to take a reasonable amount of steps to mitigate your damages. So if you are suing because you were wrongfully terminated, that doesn't mean you get to sit at home and watch, I Love Lucy reruns and eat bonbons on the couch until you win. You're supposed to go out and try and find another job. And if you don't do that, then the jury or the judge could hear evidence about, well, what would be a reasonable amount of time for you to find a new job, depending on the job market, et cetera, and come to some limitation. It's not just a license to give up. And there are good policy reasons for a mitigation of damages theory, because you don't want people taking advantage of their harm and, figuring, well, I was hit by a car and I gave my case to Larry H. Parker. I'll just sit around for my $2.1 million, right? You want people to be not wallowing in it. Finally, the Court of Appeal turns the screws on the plaintiffs in another way, which is that this pain and suffering, or mental pain and suffering, the evidence was that the plaintiffs were frightened and they were sick at heart. Their dignity suffered, and some of them cried. Some of them mourned the loss of their animals for a long period of time. Reading directly from the case, the district court seemed to think that because the horses and burros played such an important part in the Indians' lives, the grief and hardships were the same as to each. The equal award to each plaintiff was based upon the grounds it was not possible to separately evaluate the mental pain and suffering to each individual, and that it was a community loss and a community sorrow. The Court of Appeal says, no, pain and suffering is an individual and personal matter, not a common injury, and must be so treated. And damages for mental pain and suffering usually has to be based upon a physical injury. And it says only in extreme cases can pain and suffering be awarded for a injury to property. So this is where we get into some interesting law and policy issues, because the law considers animals, including pets, to be property. And so if you lose a pet, whether it's a working animal or just a companionship animal, the value of the loss under the law is that animal's treated as property. So it's what would it cost to buy another Cocker Spaniel, not what Fifi was worth to you. And so there's an interesting policy discussion there about whether it's morally right to treat animals as property.
Well, I can understand how they wouldn't want, as judges, to be inundated with, can you imagine the kind of evidence that would have to be brought in to show how important Fifi was, like diary entries talking about Fifi, like scrapbooks. It would be a very inexact sort of science, I guess. Still seems very harsh.
Well, I think so. I guess we'll take a little loop in this direction. My thought about about this area is loss externality, because it's indubitable that animals have emotional value to us, and I don't think there's any real question about that, unless someone's never been a pet owner or they're a sociopath or something. But there is some loss that's suffered beyond the, even a purebred animal. Maybe it's a $10,000 animal, but it's still worth a lot more. And people consider their animals part of their family, and they mourn them, and they, bury them and all that sort of thing. So there is a loss there that's above and beyond replacement value. I think we kind of know intuitively there's something else there. It's not this, if you have an animal that's worth $10,000 and a Honda that's worth $10,000, you're not going to, maybe if you have stickers on it, but pretty much people aren't going to mourn the Honda. You get another blue Honda or whatever, it's going to be pretty much the same thing. Whereas, and even though people name their cars and whatnot, but it's really different when you're talking about a pet, and that they sleep in your bed, and they, do funny tricks, and they bark at the Amazon packages all day long and interrupt every Zoom call, but you love them just the same. Your Honda doesn't do any of that. So we're making a policy choice that, even though we know there's a loss there, we don't want to fix a value on it. And so we're going to allow the person who suffers the injury, if someone harms your pet, you're going to absorb the mental pain and suffering, that loss, because we've made this rule that we can't value it. We don't do the same thing to bystander injury of humans. If you witness someone you love get injured, you can sue for emotional distress damages and pain and suffering, mental pain and anguish. So it's difficult to calculate. It's speculative. It's hard to put a dollar figure on your love for another person or an animal, but we do it in other areas. But we've made a policy decision that we're not going to allow that evidence to even come in. We're not going to let someone fix a value. So
it's interesting that the judges say we rarely, except in extreme circumstances, would allow any property to have this pain and suffering thing. other than a pet, what would be the more extreme circumstance where a loss of property could, under this very restrictive view, allow me some sort of pain and suffering recompense?
Yeah, I mean, I think it would. I'm not sure. The rule would be based on, in this case, whatever Utah law was, but in general, it would have to be something. Think of like an heirloom,
Mm-hmm.
or desecration of a corpse.
Mm.
There you can get emotional distress damages for desecration of a corpse, mishandling of a body. So things where the quote unquote property involved, isn't a living being with consciousness necessarily. I mean, who knows what is consciousness anyway in the first place, but that's maybe a different podcast. But the point being that it's something that's close to the loss of a human life. And they kind of leave the door open here. They don't completely reject the idea of emotional distress damages, but they're looking for particularized proof as to each individual plaintiff. And there are 8 families here. What kind of emotional distress was suffered by person A versus person B instead of a flat amount.
I think they're hoping that by shifting it to the individualized basis, that they're going to make it like basically impossible for them to submit that kind of evidence. At least some of them are not sophisticated enough. And also there might be sort of a volume of the claim, like how many animals are we talking about? How difficult would it be to prove for each and every single one, for each individual person, how they felt about them? It's a lot to do, like a mountain of paperwork, I'm sure.
Yeah, pragmatically speaking, the Court of Appeal is putting a really heavy evidentiary burden on the plaintiff, the cost of trying to prove that and coming through with, I don't know, it's the 50s. They may have photographic evidence. They may have records. They may not. It could be testimony. But it just gets increasingly difficult how do you place a dollar value on these kinds of losses and suffering? It is more or less speculation. And the only tool we have available to us is moving money from one place to another. So how do you decide the amount, and how do you set rules? And so the district court is kind of exposing some of its biases and prejudice, which takes us to the kind of the policy. Interesting, this recusal point that Kristen brought up. Separate and apart from these damages, there are basically three categories of damages that the Court of Appeal says you can have: replacement value, looking at each horse and burro, what's the market value for each one, and the loss of use value in a reasonable amount of time. With a car, it's easy, right? You think about your cars, maybe your car's worth $10,000. You can get Blue Book value. It's relatively simple to find out, especially if it's a regular car and not customized. Okay, it'd probably take you a month or 2 to get a replacement car. During the interim, you need to pay for Uber or taxis or things like that. So your loss of use value is fairly easy to figure out. You can just say, I had to go to work every day. I go 5 miles to work every day. I needed to get my groceries, and and that you could add it up. And that's the kind of proof that they're looking for here. They're not really allowing the idea of diminution of value. That's a consequential damage that the inability to continue maintaining their herds and flocks and getting to the doctor or getting medical treatment or attending ceremonies, things like that. They're really they're setting a pretty high bar of proof there. And I think finally on this pain and suffering, which was one of the biggest elements of damages, actually, the court is specifically requiring individualized proof, is essentially making it close to impossible to really prove. The final twist, the final challenge presented to the plaintiffs here is that the district court grants the request by the United States to recuse or disqualify the original trial court judge. And the reason, I'll just read from the case: a casual reading of the records leaves no room for doubt that the district judge was incensed and embittered, perhaps understandably so, by the general treatment over a period of years of the plaintiffs and other Indians in southeastern Utah by the governmental agents and white ranchers in their attempt to force the Indians onto established reservations. This was climaxed in the range clearance program. That's what we were talking about in the first place, taking the horses and burros, with instances of brutal handling and slaughter of their livestock, which the court during trial referred to as horrible, monstrous, atrocious, cruel, cold-blooded depredation, and done without a sense of decency. The court firmly believed that the Indians were being wrongfully driven from their ancestral homes and suggested presidential and congressional investigations to determine their Aboriginal rights. He threatened to conduct such an investigation himself. A public appeal on behalf of the plaintiffs was made for funds and supplies to be cleared through the judge's chambers. From his obvious interest in the case, illustrated by conduct and statements made throughout the trial, which need not be detailed further, we're certain the feeling of the presiding judge is that such, upon retrial, he cannot give the calm, impartial consideration which is necessary for a fair disposition of this unfortunate matter, and he should step aside. They quote from a case, quote, "The Indian problem is essentially a sociological problem, not a legal one. We can only make a pretense of adjudication of such claim, and that only by judging the most unrealistic and fictional assumptions. And so the case should be heard before another judge."
Even in that part, they say he wrongly believed that the United States government was removing them from their land, already putting their own perspective on it and just saying flat out, he is wrong. And then dinging him for believing that.
Yeah, I mean, the judge was outraged, so we can't have that.
Also, I mean, I think there's like a pretty obvious tension between the fact that this is a federal court applying state law where obviously the state judge has much more interest, or like the local judge will have much more interest in like what's happening in his area than like obviously these people up on the circuit level.
Yeah, it reminds me there's a federal court judge in Southern California named David O. Carter. And if you read the LA Times, he's getting a lot of coverage. He's gotten some attention because he got involved in some of the issues with John Eastman, the Trump lawyer who was subpoenaed, and the subpoena was basically Judge David O. Carter was the one that said, it looks like this is evidence of sedition. He has taken a very aggressive approach toward the problem of unhoused persons in Orange County, personally inspecting, and he's basically taken jurisdiction over the whole issue and of local governments, and really tried to enforce court orders and really push local authorities to deal with the problem. It's interesting, this whole question of judicial activism and how far should a judge go. I would argue that usually cases end up in law school textbooks because they're wrongly decided in some way, or they are controversial, or they give you room to think, right? And here I think it's pretty clear from our perspective now that the 10th Circuit was wrong and was probably acting on some racial bias, and that the district court judge who actually heard the testimony, who had witnessed, had heard about how this really horrific treatment of these animals that were beloved. Also, there's all kind of cultural bias going on, right? There's some reference to the Navajo tradition as these animals having souls and being part of the family, and applying a Western European through United States legal regime, all that, it gets devalued, whereas the local judge was really trying to put the plaintiffs in the position that they would have been but for the wrong. So you can win on liability and lose on damages. That's my point. You win on liability. There's no question in this case at all that the government broke the law, that the government harmed these families, but what are the damages?
I think a second question is also like, and I know this is not something that we consider, but like I feel like it ought to be, is how maliciously they did it. I mean, to send all these horses to the glue factory is not the same as like selling them off. I mean, this was really devastating, and I think really purposefully calculated, like, to create psychological like harm, right? To hurt their feelings.
Well, I mean, that's a great point, actually. I hadn't thought of that, but yeah, for sure. You could have easily resold the horses. They didn't need to destroy them. It was clearly done to terrorize. And the other fact I think that goes into it is that this was done while their other case was pending.
Yeah.
So they clear the native people from the land, calling them trespassers. The native people sue to reclaim their right to the land. They eventually win, but before they win, the government goes and takes all of their animals and basically cripples the community. Pretty outrageous.
It's a real like Robert Moses playbook. Like, well, let's just clear the land and start putting up the freeway before the lawsuit's done. And then once the freeway's there, great. You won the lawsuit. Who cares?
Exactly.
Ooh.
Yeah. It's just depriving. Well, and that is why remedies is so interesting, is that in this case, by so devaluing the loss to the plaintiffs, it's effectively a deprivation of the remedy. And so it's great. You can win the lawsuit, but if you don't get an appropriate remedy, then you're not put back in the same position you would have been. And it incentivizes, again, a law and policy point is if the remedy is inadequate, it incentivizes people to commit harms. We have a recent example, actually, from my own experience that I can share. And then we're going to take a break to a palate cleanser and do something funny. From my own experience, COVID essentially shut down trial courts in California, at least. No cases were going to trial. There were very few hearings. All trials were vacated. And so the entire court system ground to a halt for about 2 years. It's still difficult to get a case to trial. It's difficult to get hearings. Hearings are delayed by months and months and months. So one of the effects of that, by raising the cost and the time to pursue a remedy in court, you are essentially incentivizing people to do things that would cause them to become defendants otherwise. Because if I do this thing, I can get away with it. It's going to be years before they can catch me. And there's a good chance the plaintiff won't even bother. And so it's another version of advantages or strong player advantage, where a big business, knowing that the little people can't necessarily get them, do things that are questionable or even wrong because they know that the plaintiffs don't have an effective remedy.
I can't remember what city I feel like it was like Kansas City or something, like some place like very particularly when COVID hit was like, we're going to keep the courts running. And they found like a marked difference in crime rates. And obviously crime rates, there's all sorts of problems of how those are being reported anyways, but just the continuation of, in this case, the crime courts said, oh yeah, there's still going to be some possibility that things will be, there will be some sort of justice served, had an effect.
Yeah, absolutely. And one area that I have, I'm not a criminal lawyer, but in the civil context, one area where I can personally attest to a difference is in landlord-tenant litigation because of the COVID. First of all, their tenant eviction moratoriums that went into place for a long period of time, and then also all kinds of different things, basically making it impossible for landlords to evict and only can sue for breach of lease damages. There's a policy choice there. Someone's going to have to absorb the societal expense of unemployment, of housing loss and things like that. And we're going to decide to set the policy that we're going to protect tenants. Landlords are going to eat the cost. We're going to try to make some exceptions for small operators. And it's a policy choice. And I represent landlords. I've represented tenants. And, it is a policy choice that puts a finger on the scale of one side or another. And the fact that the courts are completely shut down essentially deprives landlords of a remedy for bad tenants. So in the effort to protect all tenants, you're protecting, ones who are, innocent. And it also has the effect of protecting ones that, maybe just decide that they just don't need to pay the rent because it's not that important.
I have definitely read of some nightmare cases, like of people who are basically professional squatters who have utilized this, like these moratoriums, just to devastating effects. So, and it's crazy because these people are basically professionals at doing this sort of terrible thing, and our laws are only facilitating that. So there's no way to even to approach getting them out of these homes or to evict them. There's nothing that they can do, which is crazy to me.
Yeah, short of breaking the law, right?
Right.
In California, which is my area, the law of unlawful detainer dates back to the mid 1800s. The idea behind the law at the time was it was the law of the gun. It was like, well, if you put up a fence and you have a gun, you're going to have the property. And so they created a special set of statutes, the unlawful detainer and a wrongful detainer. So you have a situation sometimes where someone forces somebody out, at the end of a gun. Well, even the landlord can be liable, even if they were entitled to recover possession. If they force somebody out by, basically bringing in movers in the middle of the day and just moving their stuff out, the landlord could be sued, even though they would have the right to possession. So it puts landlords in a difficult position, because if they have a problem tenant, or if people are continually breaking in and squatting, you have to file a new lawsuit each time to evict the people, and then they break back in and squat. So law is very imperfect.
And also all of this remedy part really feels like the kids game to me of would you for $1 million eat poop with ketchup and mustard on it? It's trying to set a money value on something which has no application to money, but just the mythical, well, that would put me at the same level I was before I ate the poop. Exactly.
What's it worth to eat poop with ketchup?
This is like the University of Chicago's bread and butter. Their law and economics thing is this idea that you can affix psychological litigation costs. How much would it cost for me to even bother to pursue this kind of action? I don't know if I believe in it, but people really are adamant that you could put a number value on pretty much anything.
Yeah, those are the economists for you. What's the utility, right? I mean, I guess you could. There are things that are easier and harder to prove. Pain and suffering, emotional distress, punitive damages, eating poop with ketchup. Those are all things it's hard to fix a money value to. We may need a palate cleanser from the poop and ketchup, but we're going to take a quick break. And after the palate cleanser, we'll do a little improv. And we're back. Today's palate cleanser, I have two for you. The first is very important news. NBC's beloved sitcom Night Court is back. I just want to put it out there that I am available. Should you need a real comedy lawyer to make a guest appearance? I don't have an agent. I don't have a manager. My rates are cheap. So, you can contact me at Max Headroom Esquire or at Comedy Lawyer on the socials. If you don't remember, Night Court aired from 1984 to 1992. Beloved comedic judge Harry T. Stone. His daughter will take the bench to oversee the night shift shenanigans. Good times. Our other palate cleanser today is that I want to shine a light on a specialty where we didn't think we needed one. And that is mybedbuglawyer.com. Attorney Brian Virag is regarded as the nation's leading bedbug lawyer. He's been nominated as Trial Lawyer of the Year and Street Fighter of the Year for his success obtaining jury verdicts for victims of bedbug exposure. He sues hotels, apartments, cruise ships, rental furniture, and vacation rental properties. So if you've been bitten by bedbugs, mybedbuglawyer.com. Not available in all jurisdictions.
What a great realization of a niche. This is when I moved to New York, it was maybe 15 years ago, and it was right as kind of the articles were coming out of you're going to get bed bugs, don't touch anything on the street. And so that was my constant fear. My roommate actually would put everything she ordered into the freezer for several months, books and stuff. And we got the tent that would heat things up slowly over 6 hours to kill any bed bugs. It was a massive, massive fear. And so the idea that somebody realized we need to fight against every Regal Cinema that is, no offense to Regal Cinema, but that was the one that was known in New York for a while. The Union Square Regal Cinema had bed bugs, and it was just that anybody is fighting to keep this.
Yeah. Well, I also think it's just a great example of the hyper specialization in this, age of social media. You got to brand yourself. You got to have a hyper special. It's not enough to be a business litigation attorney. You've got to be I specialize in LLCs with 3 members that are involved in magazine publication.
I remember once I was right after law school, I was talking with different firms, and this one lady was saying she was a fashion lawyer. And I was like, what does that really entail? And she's like, in truth, it means that I look at lace patterns every day and look for if there's 3 deviations or not, then there's some sort of copyright issue. Or I couldn't believe it. I was like, you basically just spend all day looking at ladies' underwear That's your specialization. That's it. So that's fashion law, I guess.
Hey, everybody's got to have a specialty, I guess.
Yeah.
Our specialty here is taking the law and making it funny.
Yep.
All right, Kelly, happy birthday.
Oh, I'm so excited.
We got you what you've always wanted, a puppy.
Oh, it's so cute. And look at its little eyes. It's so sweet and a little button nose. I'm going to name it Casey.
Okay, good. We're going to need to take a lot of pictures right away, just in case anything happens to this puppy for pain and suffering purposes. I want to create a paper trail that you love this puppy.
That's right. Your dad and I have been documenting the journey of this puppy all the way from the puppy mill we got it from. We've been continuously videotaping it because we know, having occupied many apartments, you need before photos if you're going to have before and after photos.
But I just want to play with the puppy. Maybe I could just take it outside and we could go like hang out, or I don't want to do this whole photo shoot.
Well, we'll just, we need to get evaluation points. So can you just look right straight into the camera and just tell us, how happy are you on a scale of 1 to $1 million?
$1 million. I love Casey.
Thank you. Okay, great. Let me just get you from this angle. Can you say that again? How happy are you on a scale of 1 to $1 million?
I am $1 million worth of happy. I love Casey. This is a great dog.
Right. Just to be clear, This is your birthday. This is your 7th birthday. So that's $1 million in today's money.
Right, Paul. We should just get a newspaper shot right now.
Yeah, let's get a newspaper
shot. If we have a newspaper around.
The dog's chewing the newspaper.
Okay, I'll get a shot of that. Yeah. Okay.
Guys, what would happen to Casey? I don't want anything bad to happen to Casey. I love Casey.
Nothing bad is going to, assuming nothing bad. Yeah, nothing bad.
I don't think anything. We're not planning for anything bad to happen for Casey, but with that valuation, I don't know how careful I'm going to be.
Oh, okay. I just feel like now I should keep Casey locked in my closet so that she's safe. It seems like there's lots of dangerous people out there who might harm my beautiful dog.
Right, and some of them may live in his house.
Closet dogs. Yes, but just as a warning, closet dogs rarely get large suffering damages.
Right. We're really focused on this valuation question. We know you love the puppy, but we are thinking about the bottom line. That college isn't going to pay for itself, is what I'm saying.
So I heard you got your kid a nude puppy. That's very brave of you.
Thanks. We thought, might as well. This is the time. Let's get her a new puppy.
Now, she's old enough to learn how to care for the animal and, feed it, toilet it, and also establish its value.
I don't know. I run a puppy mill, and I'll tell you, I find them just terrible pests. I'd happily exchange them for some glue if I could.
Really?
Yeah. In fact, I run a bit of a quiet operation. If you're sick of your dog and you want to pursue some sort of damage theory, I can magic that dog away.
I'm not really sick of the dog, but could we find somebody wealthy to potentially abduct the dog, bring him to you, you do the glue, and we sue for tort damages? What do you think? Is that a good idea, Paul? I think that's a good idea.
I think that's a great idea.
That's a good idea. We just need to find someone to get the idea.
Welcome to my yacht. I have heard that you need somebody to commit a minor crime. I have nothing better to do than eat grapes. So.
Oh, yes, these grapes are delicious. I will say it's so nice to meet you, Captain Moneybags.
Thank you.
Oh, now I was just curious, Captain Moneybags. You were born into money, I'm assuming, based on the name Moneybags.
Yes. My first name is Munn, and my last name is Ibags. And of course, we invented e-bags, the electronic bags. Grape.
Delicious. Well, would you like to meet our daughter's puppy? His name is Casey. He's adorable.
Arf, arf.
Wait a minute. Are you trying to trick me into committing a minor crime and then torting me into oblivion?
It wouldn't necessarily be a crime. It could be a civil lawsuit.
Ooh.
And in which case, there would just be money damage. There's no prison time. But don't you think this dog, Casey, is something you would want to steal and sell for glue?
Ooh, this sounds like a bet. And like any very, very rich man, my favorite type of bet is remedial value bets. I believe I could get away with this stealing a dog for, I'm going to say, $300. Let's do it. Give me the dog.
Mom, Dad, where's Casey?
Paul, do you want to explain?
Well,
I'm implicated, so.
There's just a trail of grapes and gold leading from my closet out to the doorway.
If this works, we're going to be able to get you a lot of Casey's. Okay. I want you to keep that in mind. Oh, wait. Are you crying? Get the tears. Get the tears. Get the tears.
I'm not good with emotions. I'm not good with emotions.
But Casey would lie next to me in bed at night and read me stories and sometimes would defend me from bullies.
Whoa, can you just say that right into the camera? Just say that into the camera. Just turn this direction just a little bit. Okay. Yeah. Go ahead. Tears.
Casey defended me from bullies at school. Some of the kids said my parents were money grubbing and that I was a loser, and Casey would bite them.
Wait, but how do you feel now that you're never going to see Casey again?
Devastated. I no longer want to work or go do homework or go to school. I don't want to go to college.
And you were going to be an astronaut and make millions of dollars as an astronaut on TV. Isn't that right?
I was almost certain to have become an astronaut. Yes, that's correct.
And your pain and suffering, how would you rate it on a scale of 1 to $100 million?
I would say $100 million.
Wait, can we just get this from another angle? Okay, just right into the camera. Just how would you rate your pain on a scale of 1 to $100 million?
$100 million.
Okay,
that's good.
That's good. I had pretty good framing on that one.
Can we get Casey back now?
Ask your father.
I mean, you just had her kidnapped, right? But we could get her back.
Oh, we were not involved with the kidnapping in any way whatsoever.
Oh,
were we? No, not at all. No, not at all.
No.
Actually, can you say that right into the camera? My mom and dad were not involved in the kidnapping in any way whatsoever.
My mom and dad were not involved in the kidnapping of my beloved pet Casey, who used to lick my tears when I was sad at all.
All right. You saw a yacht captain come into your room, didn't you?
Yes, and he was trailing grapes and gold from his luxuriously appointed suit.
Okay, wait, we're going to need to take that again, but you need to start by saying, I saw a captain of a ship. Okay, so that's not like you're answering a question, like you're just saying it. So what happened?
I saw a captain of a ship. He looked very wealthy. He had on a gold suit, and he was trailing grapes and gold everywhere he walked, and he walked into my bedroom.
And were you frightened?
I was very frightened, but also intrigued about how he had so much gold and also grapes.
All right, hear ye. I will now give my judgment in the case of Sad Little Family versus Mr. Munn E-Bags.
More grapes, Your Honor? More grapes?
Yes, please. Now, I, of course, am impartial. I am Judge E-Bags. Only related to Mr. Munn E-Bags by being twins.
Objection.
Yes?
Objection. Yes, I would like the record to reflect that your twin brother is laying across the bench, directly putting grapes into your mouth and rubbing you on the nose. And you seem to be enjoying yourself.
I will overrule that objection. I don't seem to be enjoying myself. I am enjoying myself. Accuracy is important. Now, I find that the damages done are well into the millions. A yacht, which was once unsullied by a puppy, has now been puppied, and never again can Mr. Moneybags sell his yacht and say, there's been ne'er a puppy upon this yacht. The depreciation in value of this yacht is quite extreme. So I am going to award reverse damages. And sad little family, you now owe, let me see, carry the zero, $100 million to Mr. Moneybags.
But he stole my dog.
But he was a closet dog. He was a dog in a closet.
Oh, I guess there's nothing I can do to show how individually I was really hurt by this.
Well, just say into the camera how much you hurt.
When the judge found against me and ruled that I had to pay money to the guy who stole my dog, it really hurt my feelings.
How much did it hurt your feelings on a scale of 1 to $1 billion?
$200 million.
Oh, I think we captured it. So,
welcome to the appeals court. I am Hiram E. Bags, unrelated to my two twin brothers. Now, in this appeals court, it says that you have appealed and said that the original finding was wrong.
Yes, and also we've sued the original trial judge for emotional distress damages for ruling against us.
Yeah.
Ooh, the old double suit. I love it.
It's a twist.
Oh, grape. Oh,
no.
So, do I hear grumbling in my court? We have a no grumbling rule.
I would just like to go on the record to say that grape sales, since you were taken onto this case, have gone up astronomically, and I think that that's a form of activism. Honestly, I think that you're mostly in it for the grape industry.
And I would just like to say that I'm going to just let my 7-year-old daughter advocate this case. She's clearly far more qualified than I am. I do have an interest in the outcome, but yeah, I'm just not the advocate she is. So I'll defer to her grape market analogy and also some law and economics theory, which she's been studying in her second grade class.
But that I no longer can study because I'm too depressed about Casey. The judge is joking.
Joking?
Well,
this...
Okay, I know the Heimlich maneuver. Casey taught me.
Wait, before you hop the Heimlich maneuvers, Hiram, will you be ruling in our favor? Not? Yes, absolutely.
Yes.
And you're... sorry, I know I said I wasn't going to be saying anything, but I just want to know what the ruling is going to be.
Well, sneak peek of the ruling, now that I can breathe again. I am double reversing all damages. So the damages now go back to sad little girl and her family. Grape. Oh. And I'm sorry to my twin brothers, but them's the grapes.
Speaking of twin brothers, this is Casey's twin brother, Lacey. Arf, arf.
You had another dog? You already...
Well, Your Honor, if I may be, I know I don't want to interrupt my daughter too much, but we did need to mitigate our damages.
Understood.
And your brother never bothered to ask about the availability of other dogs at the lower court proceeding, so...
Oh, darling, you are such an expert in civil procedure.
Just saying, it's not properly on the record.
Well, Paul, I think Monaco is going to be delightful this year. Don't you agree?
Yes, absolutely. We have to go.
That was such a stroke of genius getting that dog. Really, truly thoughtful, and I so appreciate you.
Thank you.
Oh, Mommy, Daddy, I'm so pleased with my new puppy. Everything I've ever wanted.
Well, I got everything I've ever wanted, which is tons of money in gold bags.
And I was able to pay for elocution lessons. Now I sound like I'm even richer than I was.
Well, sad little family. Now we're a happy little family. Let's all go and put it all on red.
Arf, arf.
Welcome back to Remedy, the game show, where we test what you are willing to do for how much money. Your host, as always, is me, an insane billionaire. Now, our first contestant is, of course, we have Roger. Roger, go ahead and come on up to the stage.
Oh, I'm so excited. I'm such a fan of this game. I've been watching it for years.
Roger, if I were to pull your pants down, what's known as a pantsing, how much would it cost for you to feel like you had your pants back up again?
Well, it's funny you should ask this. I'm going to throw a screwball at you and tell you that I actually would pay you to pants me. I love the air conditioning down in my southern border, if you know what I'm saying. So I'll pay you $100 to pants me right now.
But I like to see pain in people, Roger. That's why I have the game show. Well, what if I were to hit you in the head with a mallet? Well, imagine yourself now unmalleted.
Well, I'll tell you something. One thing, it reminds me of growing up. My father used to throw a mallet at me every single day until he was, he lost a finger in the meat grinder and left the family for the lady down the street. So, I would say I'd gladly pay you at least $1,000 per malleting. And I would be owing you money if you were to mallet me. So it'd be negative $1,000 per mallet.
I will find a way to hurt you, Roger. That is what I got money for. What if you were to be launched in the air 30 feet, not enough to kill you, but enough to really hurt on the way back down? And when you land, you're going to land in a vat of lemon juice.
Well, gee, it's so... You're 3 for 3. You keep coming up with things that are apparently hurtful, but things that I actually, in my strange way, enjoy. A lemon juice reminds me of the old granny's farm where we used to jump into lemon juice as a kid. So, you'd be throwing me right back to my memories of my childhood. I'd have to pay you at least $300 per time you threw me 30 feet into the air and landed lemon juice. That's $1 per foot in the air. So if you did 100 feet, it'd be $100 and so forth. I'm quite good at this game, I will say.
You are hurting me. I need some sort of remedial action. I'm not used to this. I'm used to throwing my money at problems and fixing them.
Oh, well, now you're making me feel sad. Now, that's a painful area, actually, and I would like to be paid money for making you feel sad.
All right.
$10,000 would be the remedy for me, for you to pay me for me making you feel sad.
Here's 10,000 fresh off the stack. Ooh, that pain felt good.
Boy, thank you. I'd be happy to make you feel sad again, provided you're willing to pay me money. This is taking a bizarre twist.
Every episode of Remedy does. And that's why we have another contestant. Now, of course, here we have the Remedy Off round 2. Now, Violet, welcome to the stage. Oh, you're ready.
You.
Fantastic.
I've never been more ready to be remedied in my whole life.
Now, Violet, unbeknownst to you, we've taken your house, dug a hole in it, and lowered it by 4 feet. So now when you enter your house every single day, you're going to fall down just 4 feet, just enough to be annoying.
But that's my dream home.
Now it's a little bit lower.
Now
we all know how round 2, it'll sink right through. Now, of course, in round 2, we try to see who can get the least remedy for the most pain. Roger, how much could we sink your house?
It's funny you should mention that. I did grow up on a houseboat, which sunk ironically, on my 12th birthday. So should you make my home sink, it would send me back to my childhood. And my sinking houseboat remind me of old Grandma Fanny, the other side of the family. We had one on the farm and one in the houseboat. And, her screams for help on my 12th birthday as a houseboat sunk with her on it. So I would gladly have to pay you at least $25,000 were you to make my house sink. I mean, negative $25,000 would be my remedy, is what I'm saying.
Well, I actually was, my mother was buried alive during the birth process, and I was born in a very claustrophobic underground situation, which deep trauma, very deep trauma. I'm very claustrophobic now, and the idea of being swallowed up by the earth is a natural fear. So I would say at least $50,000, negative 50,000.
All right, Violet is in the lead, of course, because, as we all know, famously, she was born underground. We all remember the maternity ward that was swallowed whole and the miracle babies that popped out of the ground from it. The Cabbage Patch Children, they were known as. But now we're on to round 3. Who can get a 0 remedy? What is the thing that you will take where you will be exactly the same before and after monetarily, even if scarred permanently? Violet, you're up first.
A lobotomy.
We have a lobotomist on hand, of course, just for that. Now, an interesting conundrum, because the person you are after is quite literally half the person you were before. So, even if you would incur damages, you may not realize that you need those damages. Roger, you're up next.
Well, as everybody knows, I was lobotomized back in 22, and I haven't been the same since. So I would think put me back to the 0 level, kind of like so that I don't need a remedy at all, I think is what you're saying. I don't really know. I don't think too well, but I think it would be a college education. Would pretty much be a negligible effect on me. I would be the same before and after a college education. And so therefore my remedy is 0 for college education.
Famously, college educations help regrow half of your brain. That's the motto of Princeton. Princeton, we make you twice as smart. So if you ever had a lobotomy, we will put you back at 0. Well,
so does that mean I won?
I think right now we have a tie game because the cost of a lobotomy is $80,000 per year. It's a 4-year procedure.
Right.
True.
I do that.
So we are going into sudden remedy round, where I myself go on the remedy block.
Okay.
So, Mr. Game Show host, I forgot your name due to the lobotomy, etc. Mr. Game Show host, I would just like to know, what would it take for me to be able to shake your hand without sanitizing my hand first?
$1 trillion. I've never touched a poor person, and I don't intend to.
What would it cost for me to touch the other contestant's hand unsanitized after he touches your hand?
That would, oh my God. Disgusting. I'm choking on my own saliva here. Oh.
Grapes.
No. I tried to put a grape in to shove the saliva down. Now I'm double choking.
Well, I think we would be made whole if you were to just die on the spot. So seems like
I think that's right.
Yeah.
Well, stay tuned next week for Remedy, hosted by me, Roger, and my new friend, Violet. Let's shake hands on it, Violet. Sorry, I haven't washed my hands or sanitized them.
Oh, wow. What a texture.
Hello. Are you a bedbug and you need representation? Contact me, the bedbug lawyer. Now, to be clear, I am not the lawyer that sues people for contact to bedbugs. That is somebody else. I am a separate bedbug lawyer. But if you need representation, contact me.
Have you been injured by a bedbug lawyer? Is your bedbug represented by a lawyer that sued you due to you being bitten by a bedbug in your home and then you got aggressively sued by the bedbug's lawyer? If you've been sued by the bedbug's lawyer, I'm the bedbug's lawyer's lawyer. Call me, Bob, the bedbug lawyer, to sue your bedbug's lawyer's lawyer.
Are you frustrated by the inability to bring a bedbug-related action into court? Are you waiting long and preposterously long docket times just to arrive and put your case, which is very, very important and bedbug-related, in front of a judge? Then call me. I'm TV's bedbug lawyer. I'll see your case on TV. I am neither a judge nor am I trained to be one, but I will see your bedbug-related case and I will resolve it. Let's not give these bedbugs a roadmap to evasion.
Is this you? Were you convinced that you would go on TV and finally reach adjudication with your bedbug lawyer-related problems? And now you find yourself just waiting in a green room year after year after year, waiting for your number to be called? Well, then contact me. My name is Stanny Stan, and I am the bedbug TV lawyer. I will sue anybody who claims to be a lawyer on TV. Now, to be clear, I am not myself a lawyer, but in commercials, I do claim to be one. Call Stanny Stan at 1-800-STAN. Stand stop the last and don't type because it's okay. You understand how phones work. Call me now.
Hey, Stinky, have you been watching this crazy stuff on TV?
Yeah, Pinky, I have. What?
Well, I feel like maybe we should stop biting people because these lawyers and the bedbug lawyers and the lawyer TV, but it's just confusing. Maybe we should get into another line of work. What do you think, Stinky?
Let's do it. I've got a lot of other talents, you know.
I know you were talking about getting into voiceover.
Yeah, I feel like I've got a good voice for radio, radio advertisements.
Like a morning shock jock. I think you had that in a couple of auditions. Maybe do that instead of biting people because this lawyer thing is this country's being ruined by litigation. I think
what are you crazy bedbugs talking about? I hear you over here just talking and talking. You're not biting anybody.
No, we've been watching TV and there's a whole like meta level that it's gotten to, and it just doesn't make sense anymore. We're thinking we need to get into a different line of work. He wants to get into voiceover.
Oh, geez, you don't want to be bedbugs and bite people anymore? That just seems like the only thing we're supposed to do.
Are you a bedbug who has been convinced to take voiceover lessons by your so-called friend, another bedbug? You could be entitled to damages. Damages including up to 5 ounces of blood a year in perpetuity. Contact me, 1-800 person who succeeded at voiceover training.com. My website is 1-800 person who succeeded at voiceover training.com.
All rise. The bedbug voiceover court is now in session. Honorable Judge Bitey McBite-a-lot presiding. We have here the case of Pinky versus Cheeky. Pinky case. The docket reflects that Pinky has sued Stinky for advising. Stinky has sued Pinky for advising him to commence voice lessons.
And as all voiceover court cases start, we will now, I, the bailiff, will lead us in warm-up exercises. Manala Thavaza. Manala Thavaza.
Manala
Thavaza. I love unique New York. I love
New
York.
Judge, the court is now warm. It is your court. All may sit down. Go ahead and take a little sit there.
Well, having read the briefs, I have to say that this is a compelling case. And I'm going to order, I'm
I'm going to order the bedbugs to go on the game show Remedy. I know it's an unusual remedy for a situation like this, but this is an unusual case. And I'm going to go ahead and send this case out to be on the game show Remedy. That is my final ruling.
Oh, jeez. Is the host of Remedy still alive?
He's not, but the show's still on the air for some reason. And I don't know. They just keep running reruns. So, it's not perfect system. The judicial system's not perfect. Okay. It's like they always say, it's good at moving money around.
Do you not want to put your faith in the justice system to give you the kind of results that you deserve? Clone your pets and loved ones instead. Then you can always make sure that you make yourself whole. If you should lose someone, a loved one, an animal, we'll have another one waiting for you. Something the justice system can never provide. Call us at Clones R Us. 555-5555.
Paul, can you come in here and look at our daughter's dog? There's
What?
It's a very strange thing going on in the back of the dog. Just quiet, don't wake her up.
Yeah, what is...
It's,
Oh my
you
goodness.
see this just look through this magnifying glass. There's all these it's like little teeny tiny lights and cameras and
Yeah. I think it's a bed bug court.
do you think we could maybe film it?
Oh, I mean, I've got the tiny camera.
How much do you think we could make? We could probably make that at least a couple $100.
Yeah.
No, let's okay.
What are you guys doing?
Nothing.
Nothing. We're just
You're not going to steal Lacey, are you?
we're petting Lacey. We're just checking Lacey for lice and fleas and insects and do you mind just tidying up your room just for a minute because we
Sure.
yeah. All right, let's just get the shot real quick while she's out. Excuse me, little bed bugs. What's it worth to you to not get squished?
Yeah. This is a bizarre situation, but I'll easily pay like $5-10 to not get squished.
Yeah, I got about $7 in my bedbug bank account. I'd give $7 to not get squished.
Well, I don't know.
Geez, it's been hard to be a bed bug lately. There's not been a lot of voiceover work or biting, so I don't have much cash handy.
Well, I think that decides it, Paul, don't you think?
We need the $12.
I think you're right. All right. I guess we'll just put this up on YouTube.
Welcome back to YouTube, the television channel where we show random YouTube clips. Oh, we've already run out of money and our channel has already been pulled. But you can subscribe to us on Paramount Disney Plus, where we have been combined into a new channel. Signing off, it's me, a bedbug. I took voiceover lessons and I no longer sound like the squeaky little bedbug I was. Since the channel was canceled, this is me saying goodbye.
And goodbye. All right. Well, that was a journey as always. I appreciate the exploration on many levels. I don't know if I could diagram where we went there, but that's something that maybe Curtis will cover on Improv Beat by Beat, Bizarro World Edition.
I feel like that was how most lawsuits go, right?
It is.
Yeah.
It's usually, there's usually a lawsuit and then a lawsuit about having the lawsuit. And then usually voiceover training comes in there at some point in time. All right. Well, that's our show, folks. Shameless self-promotion from my two co-hosts. Let's have Kristen start first. Where can people find you?
I am performing very frequently with my troupe, Sorry for Partying, here in Austin, but also on the internet. There's a couple great storytelling videos up on testifyatx.com.
Thank you, Kristen. And Curtis.
If you are in Los Angeles, you can see me with my current UCB Herald team, Ghost. And you can also see me performing with Megaplex, the improvised movie. You can also find my SAT book, Laser Focus on SAT Math, on the internet. And you can find me anywhere at Actually Curtis. And you can find my improv podcast, Improv Beat by Beat.
Awesome. I'd like to thank my crew, Curtis and Kristen, for joining me today on our journey into madness. I'm Billy DeClercq. I am on the socials at Comedy Lawyer. That's my new social media handle, including Truth Social, Parler, Twitter, Instagram, TikTok. I've not put very much up on any of those, but it is what it is. I'm ready for the apocalypse. Bye.